Good morning, colleagues, and welcome again to this meeting of the Board of Internal Economy. And allow me to welcome, j'aimerais accueillir un nouveau membre.
We would like to welcome a new member of the board, Ruth Ellen Brosseau. Welcome. We will begin with the minutes from the previous meeting. Are there any comments on the minutes from our last meeting?
Are they approved? Is it agreed to approve the minutes? Agreed. Any business arising from the minutes? Seeing none, we'll go on to number 3, harassment prevention in the workplace. Et je donne la parole.
I will give the floor now to my colleague, Michel Patrice, has decided that he will be speaking to us. Thank you very much, Mr. Chairman. Mr. Speaker, I've been eagerly awaiting this meeting to talk about harassment with you. This is a very timely and urgent issue. Over the last few weeks and months, we have found out about a few incidents that have taken place in the House of Commons over the last few years. Harassment has always been unacceptable, and now it is, in fact, intolerable.
For them, nor the employees in the House administration or volunteers should be subject to harassment, bullying, or abuse of authority. I know from our own discussion that you share my views. With your support, we will continue to strengthen the harassment framework that is already in place. As, importantly, we wish to ensure that everyone is aware of that information and help is available. I will now turn things over to Pierre Parent, Chief Human Resources Officer, who will tell you about the harassment prevention program, how it works, and how we can work it even better. Thank you.
Yeah. Merci, Monsieur le Président. Merci.
Thank you very much, Mr. Speaker. Thank you, Michel. We will talk to you about the two policies. Miriam will talk to you about the House of Commons policy, and I will talk to you about the one that has existed. We take any harassment incident seriously. We provide support to the members of Parliament, to their offices.
Parliamentary community is our priority, and we are proposing additional steps to reach that goal. Today, there is a framework in place with different components that provides Member of Parliament, House officers, research offices, and their employees, as well as House administration employees, with mechanisms to prevent and resolve alleged harassment situations. Firstly, in December 2014, the Board adopted the first House of Commons policy on preventing and addressing harassment, which applies to members and House officers as employers, as well as their employees and employees of research offices. Secondly, in June 2015, the Standing Committee on Procedure and House Affairs adopted the Code of Conduct for members of the House of Commons, sexual harassment. It came into effect at the start of this Parliament. It covers member-to-member situations and secures the commitment of members to provide an environment free of sexual harassment. Every member is required to sign the pledge form, and all members have done so. In addition, the House administration policy on harassment prevention and resolution in the workplace has been in place for several decades and applies to all House administration employees. The latest version was updated in April 2015. In all the policies, there is a process in place for filing informal and formal complaints, investigating and reporting, appealing decisions, communicating findings, and ensuring that corrective action is taken. Dans le cadre de la politique, je dois présenter...
With this policy, I provide statistics annually. There are two annual reports that have already been provided, and in the first period, 2015-2016, there were a certain number of incidents, and there were 19 in the second. There are requests for information as well as more official queries or complaints. in the second period, there were 6 of 19 that were requests for information.
Rights of both the complainant and the respondent. It is vitally important that we make sure that the person feels safe talking about these difficult situations and that we protect the private lives of the individual who raised these issues and ensure that both parties benefit from fair due process. So, what do we do to support this framework and to address issues that arise? During their orientation, members are given information regarding the policy and code and affirm their commitment to supporting a harassment-free workplace by signing the pledge form. As I mentioned earlier, all members of the 42nd Parliament have signed the pledge form. With the launch of the policy, the House Administration offered members and their staff access to an informal conflict resolution program known as the Finding Solutions Together program, which Myriam is responsible. Key to this program is access to Myriam, who is available to offer members and their employees counseling on workplace conflicts, including harassment prevention and, if appropriate, mediation. This program has been used by members and employees in the past 2 years and has been instrumental in resolving some of these cases as early as possible in the process. Another
critical service that we provide with respect to harassment prevention is training. Online training was introduced in December 2016 to raise awareness by members and their staff of harassment and the services available. There are scenarios and questions and information included, as well as supplementary resources. The participants are identified, or rather have the option to carry out to the training voluntarily. 647 people have taken the training, and they can do the training when it suits them because it's online.
Of offering in-person training in a classroom setting. As such, we have been working with an external training expert to develop a 3-hour in-class session, which will start shortly. WIPs have been very supportive in this initiative and will ensure that the respective members are available for the training. We anticipate being able to offer this session to all members before the summer break. We are also developing additional training sessions, and we will be working with the WIPs offices to provide further training to all staff, both on the Hill and in constituencies. The Speaker has asked that we provide the necessary support for staff and members and address any opportunities to improve what is currently in place. Consequently, we are making the following recommendations. Firstly, that employees of members, House officers, and research offices, including interns and volunteers, be provided with clear, easily accessible information regarding the code and the policy as part of their orientation, more specifically with their letter of offer. Secondly, that the classroom training being developed be made mandatory for members and House officers, and that the training session be made mandatory for the employees of members, House officers, and research offices, including, of course, interns and volunteers. Finally, having worked in this field for 25 years, I know that the foundations of our program are strong. That being said, there is always room for improvement. I'm happy to take any questions from the board members.
If there are any questions or comments from members of the board, after which we'll go to the recommendations in due course. Ms. Bergen, excuse me.
Thank you very much. Thank you for your presentation and the good work that you've done. I do have a question I haven't scheduled in, but I haven't taken the course yet. Can you just tell us a little bit about what's in the course? And I'm thinking, you know, for a lot of people, they sincerely, sometimes, you know, as they're guiding their employees or wanting to get their work done, they want to do it in a respectful way. And sometimes there's a fine line between shouting out orders, or not shouting, but giving orders or asking somebody to do something and being disrespectful. Can you just let me know how we've developed our harassment policy training so that we aren't kind of guessing on that, but that we actually have professionals and best practices, and that we can give very clear guidelines to our members on what's appropriate and what is not appropriate?
Yes, and I'm happy to report that we test drove the clerks manager group and myself on Monday morning. We test drove the training, and it will address just that in a sense that and as you mentioned, there's a fine line between frustration and harassment and what constitute and what is the next step for a behavior to constitute harassment. And we've built that training session to basically change culture. So the entire training session is designed around that. Of course, you'll get definitions and what constitute harassment and some of the guidelines that can indicate what could be harassment and what is not harassment. But the entire 3-hour session, of course, we would have liked to have maybe 6 hours or 2-day training session. But in 3 hours, I think what we've been able to achieve is impressive, and I'm sure you'll be very happy with the results.
Just to be clear, that where did we pull the information, and how did we come to the material that's part of the training session?
We've dealt with a firm an expert firm, ADR Education, that's basically specialize in training and harassment training. So we work with them because we didn't want to provide members of parliament with a training session that you would give someone at the beginning of their career. I think you're a different population and you have different needs. I've always said that you're different because you're members of parliament 24/7. So we have to address that, and we have to be mindful of that. And so you have to address behavior that could occur in a social event over the weekend because you interact with your employees. So these are important factors that we need to consider. So we did work with specialists in the field, but we did have input on what constitutes a reality for members of parliament.
Mr. Strahl.
Thank you, Mr. Speaker. Just a question currently before the House, not to presume the outcome of the debate and vote on Bill C-65, but assuming that that does pass through both the House and Senate, as is regarding harassment in the workplace, we are embarking, certainly every Conservative member of Parliament from the leader on down will be taking this training. I'm just wanting to make sure that we're not taking training that will need to be, we'll need a remedial course right away because things have changed with C-65. Has that all been taken? Are those the possibilities outlined in C-65? Were those taken into account as this training was developed?
The training, as I mentioned earlier, is very culture-oriented. So basically, we're confident that any change legislation will bring that will still remain relevant. What could change is the material that we produce as information, because we'll produce, and you'll see more and more of these awareness pieces from my office. For instance, we're working on flowcharts and information so that you can understand the policy much better. If that needs to be adjusted, that's an easy one. So, and we're monitoring C-65, and I know that the regulations are not drafted yet, so it's difficult for us to form an opinion. But I'm confident if we're talking training only, that it's going to stand the test of time.
Thank you.
Je vois que une recommandation, c'est proposé.
You've recommended that training on harassment be provided to members and House officers, and training and staff. It doesn't say how often that training would be provided. It's a good idea to have a refresher from time to time, maybe every year or something. What are your opinions on that? I was able to speak with the whip's offices, and for this year, every whip's office has committed to provide time for all members to take the training. We want to provide the training to all members and give them access to this training. So every time we have a new parliament, when we have a by-election, we have to make sure that everyone gets the training. Perhaps in the next parliament, or from time to time, if we need a refresher, then I know that 3 hours is not easy to find for members, but we've consulted the whip's offices on that. Can you tell me whether there are best practices in this area regarding the frequency of training? How long should it be between refresher type courses? I don't think that there are any actual best practices. It isn't a good idea to give somebody training at the beginning of their career and assume that it will still be valid for 20 or 30 years. It would be appropriate, I think, to have training every 3 or 5 years, perhaps reminders on certain points or concepts. Thank you. Ms. Brosseau.
For the presentations, I would like to commend you for all the work that has been done, the collaboration. I think this has been, a long time coming, and I'm happy that we're here and we're taking these steps in the right direction. I think there's been discussions from all sides that we would like to make sure that our staff members are included in this process, and so I would look forward to how we could make sure that if our staff on the NDP side would look to use some of the services, that they would be accepted, looking to how we can get agreement at committee publicly.
We're working on we've already started working on this part of the training. The challenge for staff is probably more kind of logistic, because as you're aware, most of the staff members are in the constituency, so that presents a challenge. And I know that at my initial discussion in early January was to maybe take advantage of the I think the annual professional development day that some parties have. I think your party was in last December. Yes. Was to take advantage of that. But I'm hearing maybe interest to having these sessions maybe earlier. So we're trying to work with our provider to see if some of these sessions, if we could start before the summer break. But the logistics will probably present a challenge, but definitely it's a priority for us.
I think I was going to clarify. It's more for like the mediation, and you were speaking to more of the fact that we have offices in our ridings, and we're going to have training for our staff back home, and we're going to obviously be doing ours in June when we have our staff from constituencies come up. But I'm talking more of the lines of making sure that our members have access, or not our members, our staff have access to the same.
Members, I think the board may recall that the NDP was not included under the policy because you had your own policy in relation to your collective agreement. But now you're asking to be included, and yes. Is it agreed that should be the case? We amend the policy to do that? That's agreed. That's agreed. Okay. Perfect. Anything else, Member Rousseau? And then if not, I have Ms. Chager.
I would just be building off my colleague's comments. So I know there's 20 sessions that are for members, and I'm wondering if there is a defined number of sessions that will be available for employees. So that's my first question. I do like the idea of the mandatory training, so I'm wondering if you're referring to the online or the classroom, if we're differentiating between the two, or what the thought process is. I'd also like to highlight that this place is constantly changing. So there are members that are coming and going, so there is by-elections. So I would be mindful that when a new member comes in, regardless of whether it's at election time or whether it's at a by-election, that these services be rendered. I recall when I was first elected, there's an overwhelming amount of information that's provided initially. Some of it is maintained, and some of it it's just it's unfortunate, but we don't really get to remember it. I know there's one password that I still can't remember, but the good people here have been able to give me a new one. So we get through those times. So I just want to be mindful of the conditions when new members are coming in. I think no differently than CPR first aid, there is constantly refreshers that are necessary. So I think we should take the time to define what that looks like, to ensure that people are always up to speed, especially new employees, new members. So I just want to thank you for the good work, and just want to understand how many sessions will be available. And I would love assurance to know that the 20 sessions that are available for members will be enough for all members to participate.
Password. Yeah.
Thank you for your question. The 20 session was just kind of an approximation. If we need 23, we need 25, that will not be a problem. So we're working with WIP's offices for the logistics because I think one good thing that turned out of this communication is that every party decided to be more heavily involved than if I had open enrollment. So every party has reserved sessions, and then the scheduling is done with my office in collaboration with the WIP's offices. So if we require more sessions, we'll organize more sessions, and that should be as required.
So you referred to parties. I believe that when it comes to wanting to create a new culture, that if it is mandatory training, that parties should not be able to override, and so therefore I would ask about independence.
We're dealing with independents. So far, those have reached out to, have accepted. So I'm still waiting for one or two answers. So we're dealing with the Bloc québécois and the Groupe québécois parlementaire. So we're going to deal with those groups separately. But the goal is to ensure that everyone has access to the training.
Of course, I would note that the second recommendation is proposing that the classroom training on harassment that is currently being developed be made mandatory for members and House officers, and that the training sessions be made mandatory for employees of members, House officers, and research officers, including interns and volunteers. I think that helps further to answer your question. Mr. Straw.
On that, if we're going to talk about the recommendations that have been presented, certainly we have no issue with the first one that talks about this being part of the onboarding process when a new staffer is brought on. Right now, there are mandatory documents that are provided that an employee must indicate that they've read, they sign that. I think making this part of that is a good idea. It catches everyone at the beginning of their time here. The second part about the mandatory training. When you indicate that something's mandatory, you're indicating that there is a penalty for failure to comply. So I guess I would look to this group or to get some feedback if that is mandatory and that the WIPs will take care of it in terms of enforcing that for their parties. Does that then fall to you, Mr. Speaker, to enforce that for independents? And what does non-compliance look like? Because though we have the ability to encourage members, and we have no problems in this Parliament getting people to sign on, one can envision a situation where a very independent-minded member would say, I don't need this, I've done it before in my past life. I just want to know if we're talking about a mandatory, that to me indicates that if someone fails, a member fails to comply, that there will be a penalty of some sort. And I just wanted to get an idea from the administration or feedback from my colleagues as to what does that look like and how can we enforce it.
I think I'll start by asking Mr. Parent to give his sense of how he expects this to work.
Yeah. Maybe just to start, in this round, what I'll do is, because it's not mandatory by the board, the WIPs have made it, or the parties have made it mandatory. So what I will do is I will provide each WIP's office with a list of attendance. So that enforcement will be done from the WIP's office. If in the future the board makes it mandatory for all members, including independents, yes, I will. For those who don't have a WIP to enforce it, and I'm not an expert on how the board or the speaker or the clerk could enforce it. So I don't know if. Maybe the clerk or the law clerk, I don't know.
I guess if I might just...
Oh, sorry.
Go ahead.
Oh, I missed, sorry.
If it's an independent who does...
Yeah, well, I think clearly it has to be reported to me or whoever the speaker is at the time, of course, because there is no whip for that member. Yeah. But I suspect we're going to have some conversation about what happens in either case.
Mm-hmm. So I guess the question would be, you said that there was 100% compliance with people signing the pledge for the code of conduct. I guess that was probably I'm not trying to be difficult. I think this will be easy to enforce. I just if you're putting that in there, I think you want to have some idea of what it looks like if there is no compliance. If a member goes rogue and says, "I'm not doing that," are you garnishing their wages? Are you not recognizing them in the House? I'm serious. I think there what are we doing to make this real, other than, it's mandatory, but if you don't do it, there's no penalty. I think we need to talk about that.
Well, I think that that we should have this discussion about what the consequences will be. One obvious thing could be that that it's reported here, that I report to the board if certain people, and obviously we think, usually the whips have pretty good capacity to get the members to cooperate with, especially things with this that everyone should do anyway, right? Although I'm sure it can be challenging at times, but on some issues at least, probably not this one. But the other thing is that there's the question of, if you're not going to comply with this and you resist it, the board might ask itself, what should we do about that person getting resources to hire people? Should we say, well, wait a minute, you can't hire unless you deal with, or again, it's a question I'd like to hear what members of the board's view on that is. Is it simply good? Is it sufficient for starters to report, have their name reported? Because that obviously is going to be, I would think, embarrassing for a member to have that publicly reported. Do we go beyond that? Do we need to at this point? What members feel we should do in that regard? Because I'm glad you've raised this question of the consequences for people who don't comply.
Well, certainly, I would support. Obviously, there needs to be a time frame given. There are, some people are, and we talked. There's information in the budget about people going on longer leaves now, or people that are ill, or there's circumstances that do arise that prevent people from perhaps doing it as quickly as another member could. So this would have to be if someone is acting in bad faith, and we go down this line of who's making those determinations. Probably again you, Mr. Speaker. But I think the threat or the promise of public, the list of people that have not yet taken that test, I would certainly support that. And in this public forum, I think they would feel some pressure from their constituents as well to engage.
Thank you. Ms. Bergen.
I'm just wondering if maybe it would be wise if we come back to this and talk about it, because even your suggestion about maybe withholding funds from them to hire somebody, really there we would be penalizing an employee, and that is not what we would want to do. Or if this person there's legitimate real reasons as to why they haven't taken it, we also would never want to embarrass them, because it's hard. You can't take that back. And so I think we do have to think very long and hard about it. And my hope would be, I think, and we'll see from what happens with this initial training, that everybody wants to do this. So I think we should be planning that we'll have 100% support. And if somebody doesn't, that we'll work with them and find out why, and find ways to mitigate whatever reasons it would be that they're not taking it. I think we should go on the presumption that all of the members of Parliament here want to do the right thing for the right reasons, as opposed to let's punish them because they're not behaving the way we want them to. So maybe we should think of it in those terms, and then look at what we could do.
Well, if the board wants to, at some point, have measures, we can talk about that. And obviously the members of the board can discuss that. And of course, the alternative is that if it's going well, people are all taking this training and there's no problems. That's great. We could say that, well, if there's a problem, we'll cross that bridge when we come to it, right? And figure out. But I leave this for discussion further. In the meantime, are we ready to accept the two recommendations as written? Is that satisfactory? We have agreement. Yes. Okay. Monsieur Parent, merci beaucoup de votre présence.
Thank you very much for being here, and for both of you witnesses for being here. Now,
proposed legal fees policy. J'invite le greffier de droit. Qu'est-ce que c'est en français? Greffier légal? Légiste, excusez-moi. Okay.
Talking here about the legal fees policy. Philippe Dufresne, who's right behind me.
Alors, merci beaucoup, Monsieur le Président.
Thank you very much, Mr. Speaker and members of the board. I'm pleased to be here this morning to present our proposal for the adoption of a new policy on the reimbursement of legal fees for members. And in some cases, and we will discuss this, for staff. That's new. Under the leadership of the Speaker, we've looked at this policy on legal fees from the approach of protecting employees and making sure that the workplace in Parliament is free of harassment. This policy on legal fees reflects that and our desire to respect human rights. The new policy that we are proposing sets criteria for reimbursement of legal fees for members. It also makes it very clear that legal fees would not be reimbursed in cases where a member was found to be at fault, where a decision maker or the court had decided that harassment had taken place, for example. So we want to make that clear. We also want to increase proactive disclosure for the reimbursement of these kinds of fees, and this is certainly also new. We want to align this with the approach that we're taking on harassment incidents in Parliament. So we're proposing here measures that would put staff and members on an equal footing where there are harassment incidents. So we're going to provide support at the beginning of a situation where there may have been harassment. That is when an initial legal finding is needed, and also at the end of the process.
Is very much designed to provide greater protection from harassment and to provide greater clarity in terms of the criteria that would apply for reimbursement of legal fees. And so this occurs in situations where members must seek legal counsel from the outside. My office is legal counsel to the institution, and we provide legal services to members, but in certain circumstances, including harassment allegation or litigation, members must seek outside legal counsel, and in those situations, they must seek reimbursement of those fees to the board. The current practice of the board with respect to the reimbursement of legal fees is very much to focus on whether the litigation flows or the legal matter flows from the members' parliamentary functions. And the reimbursement is made at rates pre-established by the board, which are pegged to those of the Department of Justice. They are reviewed by my office, and a recommendation is made by my office as to the appropriateness of the reimbursement, and it's done on a case-by-case basis. The expenditures for those reimbursements of legal fees are reported annually in the Public Accounts of Canada. So that is the current practice. What we are proposing to you today is to include additional criteria to achieve those principles and purposes, objectives that I've highlighted at the outset, which are, again, to ensure that a member is not reimbursed for his or her legal fees in a situation where the allegations have been substantiated. And so a member who is found to have harassed an employee, sexually or otherwise, would not see their legal fees reimbursed. And so the board would not be financing this legal representation for members in such cases. And we would want to provide greater disclosure of the funds expended. So in addition to the public accounts annually, we would provide quarterly reports. The board would provide quarterly reports of the amounts, including the number of requests. And so that would provide greater information in terms of the public funds expended for those purposes. And in cases of harassment, we would provide additional measures to support employees and members involved in situations of harassment. We've heard time and time again in context of harassment. Before I was appointed law clerk, I was human rights lawyer for 15 years. It is fundamental to have initial support and adequate information in terms of complainants, individuals who feel that they have been victim of harassment, to understand the process, to understand their rights. And Madame Brosseau, I think that in one of your earlier questions, I think you alluded to that, to what extent are we accompanying complainants in the initial stages. And so we would propose additional support for members and employees in such cases specifically, and at the outset, financial support, and at the end of the process, possibility of having legal fees reimbursed. And so specifically, what we propose is to include the following eligibility criteria when members make a request for their legal fees. This would be the general approach in all cases, which is that the member cannot have initiated the legal proceeding. So this is meant to be support to a member who is a defendant, not a plaintiff. The legal fees must be incurred in discharge of the member's parliamentary function. That has to remain, because that is the underlying condition for support from the board. The request for reimbursement would need to be made at the conclusion of the proceedings. And this is so that the board can have all the information, in particular to assess the next criterion, which is that the allegations against the members have not been substantiated. And if the allegations are substantiated by a decision maker, then the legal fees would not be reimbursed. But if they have not been substantiated, then the board could decide to reimburse them. The member needs to have complied with the legal fees policy, which is to say they have to have kept my office informed of the process and of the development in the matter. And as a last criterion, the board must determine that reimbursement is appropriate in the circumstances. And so you retain this ability to determine that in a given case, even if the other criteria are met, that it would be inappropriate to reimburse those legal fees. So under this new approach, again, very clear that a member against whom allegations have been substantiated will not see their fees reimbursed. The board retains the discretion. I would continue to provide recommendations to the board in terms of approving such requests, and I would apply those criteria in all cases. The reimbursement would continue to be at the rates pre-established by the board, which is to say no greater than the Department of Justice and the Senate. And indeed, they could be reassessed periodically. Currently, they are certainly pegged at the rate of the Department of Justice. The board would retain the ability to grant exceptions, as it does generally, but we would propose that as a transparency mechanism, that if the board did this, this would be reported in the board meetings minutes to reflect that an exception to the policy has been made. The reporting would continue, as I have indicated, in the public accounts, and there would be additional disclosure of the aggregate amount of legal fees reimbursed to members and employees under the policy each quarter, in addition, including the request for reimbursement. Now, with respect to harassment, we feel that additional support is warranted for complainants and members, employees and members in cases of harassment, and so we would propose only for cases of harassment the additional two forms of support. One would be financial support of up to $5,000 for both a member and an employee in a situation of harassment. This would be for the purpose of obtaining independent legal advice at the outset. This would be managed by my office, and the request would be made to me or via the speaker, but I would make the decision to grant or not that support of up to $5,000, and the condition would be simply that it's a matter of harassment involving a member and employee or involving two members. And so this would not need to come to the board, and it would provide early and flexible support for employees and members at the early stage, because it is helpful to have a better understanding of the rights, of the issues, of the likelihood of success, and so on. And so we feel that this would be beneficial, and it would provide support to people in vulnerable situation at the outset of the case. As an additional measure, we would provide, and this is very much to put the complainants and the members, the employees and members, more on the level playing field. We would provide for the ability for complainants to seek reimbursement of their legal fees in situations where the allegations have been substantiated. So there again, that request would come at the end of the process, and a complainant who has seen her allegations upheld, substantiated, would have the opportunity to seek reimbursement of legal fees. And so this is a very new measure, but we feel that it would provide additional support to individuals so that they feel comfortable, confident that they can raise those in terms of process, and that this would support a harassment-free workplace. And so that is the outline of the policy, which we feel again would be beneficial, would provide greater clarity and greater support in preventing harassment. And so with this, I will open to your questions.
Thank you very much, Mr. Speaker, and thank you, Philippe, for that presentation. It was a good starting point, and I think that the recommendations are appropriate. As you have said, this will bring positive change, in my opinion, in the balance between support for members and now for staff who previously did not have access to this financial support. So I think this is very constructive, very helpful. I have three rather specific questions because I think it is important for everyone to understand certain distinctions.
Be in the discharge of a member's parliamentary function. That's a phrase that we've here at the board often. I think it would be interesting for you to explain why that's the case and why in other expenditure contexts that necessarily has to obviously be part of the requirement. The other thing, Philippe, that I think would be useful is to clarify that when you talk about either the $5,000 sort of upfront support, which again I think is a positive suggestion, a very positive suggestion, available to employees as well, of course, very positive. The reimbursement of legal fees that you referred to at the end of the conclusion of a particular process has nothing to do with the payment of a settlement. There is some confusion, I think, in what people have asked me about, whether the board is paying settlements, in other words, monetary awards, separate and apart from reimbursing legal fees that you and your office audit as being proper and being subject to that chart of hourly rates, which the Government of Canada maintains lower than when our Speaker practiced law. He wouldn't have charged such low rates. So congratulations, Philippe, on...
But I wasn't a UNB Harvard lawyer like you.
Okay,
So.
well, that's right. You
much higher, I'm sure.
You didn't get into your first choice, Mr. Speaker, so you had to go to Dalhousie. But Philippe, so I think it's important to draw a distinction between the reimbursement of the fees, separate and apart from, and obviously under no circumstances I would suggest, and I think that is what you can confirm, is the board paying settlement amounts, monetary awards. That clearly is a different discussion that is not part of reimbursing legal fees. But again, I've seen people conflating the two in public comments. I thought that was interesting for you to clarify. And a final thing, there is, again, in the public discussion of this issue, some commentary around why don't, in the disclosure, the greater transparency which you're proposing around these expenditures, again, something certainly I think is positive. There is a concern or a question that's often raised about why don't we use the names of the people, of the person, for example, the member who was being reimbursed. I think I understand, and perhaps you could refer to other similar workplaces, municipal councils, provincial legislatures that have adopted similar policies to what we're discussing today, why there is a valid reason around some of that disclosure. I suspect and believe it's around inadvertently identifying, for example, people who've been subject to harassment, to people who come, it can be used to discourage victims from coming forward. I wonder if you could enlighten us as to why, in your view, that transparency finds the right balance.
Absolutely. Thank you so much for those questions, Mr. Leblanc. In terms of your first question on parliamentary functions, that is very much the overarching theme with respect to appropriate uses of parliamentary resources made available to parliamentarians. And so in the members' bylaw that the board has adopted, it is very much the guiding principle that the resources made available to members are only for carrying out of members' parliamentary functions. There is a definition of what does not constitute parliamentary functions, private interest matters, electoral re-election matters, support of a political party in elections, and so on. But it is a recognition that this is to support the work of members as parliamentarians. And so we feel that this legal fees policy should be no different in terms of its scope. With respect to the $5,000 up front, the purpose of this would be very much to provide this initial support to get legal advice, and it is separate from the request that could be made after the fact by a member or a complainant. So the member could get they could both get up to $5,000 to get that advice, and then at the end of the process, the member could make a request if the allegations had not been substantiated. The complainant could make the request if the allegation had been substantiated. If there had been a settlement, and this is linked to your third question, both of them could apply to the board to seek reimbursement of their legal fees, and then it would be up to the board to decide whether and to what extent it's appropriate to do so, and that the sixth criteria that talks about appropriate in the circumstances would become relevant, and I would be providing you with my advice in the circumstances, having regard to the circumstances of that settlement. In terms of paying for the amounts under the settlement, that's not what we're talking about here. We're talking about reimbursing legal fees that the parties incur. In terms of a settlement, and there's a provision for damages or amounts to be paid out, that's a separate matter. It has not been the board's practice to reimburse such settlements. It has, in the last 5 years, it has occurred on 3 occasions, and none of those involved allegations of sexual harassment. And so it's not the board's practice, and the board can certainly decide to make it a practice that it is not done in any case. But it is a separate point from this legal fees policy proposal. And in terms of disclosure, absolutely, confidentiality is an important element in dealing with these things, certainly from the complainant's perspective, to feel that free to raise these things in confidence. And this we'll be talking about in the upcoming item in terms of how do we have those discussions about reimbursing legal fees. But in my view, it's important to have these discussions in private, because we do not want to have the identity of complainants revealed in this context, and in terms of the publication of the expenses, the best practices are that you don't indicate the name of the parties involved, but rather the amounts.
Mr. Straw.
Yeah, just a few questions. There have been some of the incidents that have been in the public have raised questions. Does the policy only address situations with current members and current employees? Would that be my understanding of how this would work? Or could a former employee bring a complaint against a current member and take advantage of this fee, this new policy?
We are proposing that this legal fees policy be effective as of the date that it is decided, so as of today. And if a request is made and it deals with a situation that has occurred while a member was a member, or the employee was an employee of the member, we would look to see, is this something that was related to the parliamentary functions? Is this something that has occurred here in the context of members' parliamentary functions? And if so, we would bring it here with a recommendation. Now, the timing of it and so on, I think these would be circumstances that could be considered into the appropriateness of reimbursement.
Right. But for the $5,000 that does not require the board's intervention, but that would become kind of you would have the discretion to do that, would situations that involved kind of that former employee or former member that had the allegation was of harassment or misconduct in a parliamentary function, that would that come back to the board? Did you envision that this $5,000 upfront fee would apply to people that perhaps were not currently either elected or currently employed as
That's a decision for the board to make. My proposal would be that as of now, claims that were made as of now could be eligible for the $5,000.
Regardless of whether that person was still an employee. Okay, I just want to make sure I understand that.
Sir, if I can, before going to Ms. Bergen, it seems to me that, let's say you're in 2020, January 2020. There's just been an election, and someone comes forward in January, February with a complaint, right? Related, and it was, in the office circumstance, whether in the constituency or on the Hill. It seems to me that that's part of the parliamentary functions. The key question is parliamentary functions, but again, as Mr. Dufresne has said, it is up to the board to make that, to determine whether they figure that should be. My view is that it should, but I am open to the views of members on that.
Certainly, and I just was trying to understand. I think obviously the board has the ability to make any decision on legal matters that are brought before it. However, what we're asking for here is, with this $5,000 amount that is provided to a complainant and a member, that's where I would like some clarification as to if that's just envisioned for current employees and current members. That's okay. I think there could be situations though where we may be asked to weigh in on whether it would be appropriate if someone who's left the Hill and a time period later says, yeah, I did experience something. Are they then covered by this? So maybe we can talk about that. We certainly support the move to go to this for current and current. That's probably the easiest way. I also, just to clarify, the $5,000 amount that is given to both parties in a complaint, or up to, I understand, it's not necessarily just a check at the beginning, but that amount, would any attempts be made to recover that amount should the member be found to have committed misconduct or the complaint be deemed to be vexatious?
And Mr. Schull, the answer is no. The purpose of this initial $5,000 is for both to know that they have this amount of support without risk to them. So they get this advice, they can go to mediation, they can assess the strength of the case without having to worry about having to reimburse that at the end of the day. In excess of $5,000, that's where the risk management comes into play, because the reimbursement of those would depend on the outcome of the matter. But we feel that the initial $5,000 will be beneficial so that both of them can get that advice at the outset.
And will those $5,000 amounts be reported with the proactive disclosure, or will they, as they happen, quarterly, or will those be just reported at the end of the process when a claim is either, when additional fees are paid out, et cetera? I guess I'm just trying to figure out when that will be proactively disclosed.
Those would be proactively disclosed quarterly. Every quarter we would
at the beginning report. Of the quarter in which that process began, not perhaps at the end of it. Okay. Right. And then finally, the proposal was, as it says there, if the matter's settled or substantiated. I guess what happens if a case is abandoned?
Well, if a case is abandoned, it has not been substantiated, and if it is settled, I think if it is abandoned in the sense that it ends, and so there is a resolution of the case in that sense, the claim could be made and it would be looked at. In those situations where it's not substantiated, it's going to be up to the board to determine whether it's appropriate and the extent to which it's appropriate. So if you have a situation where it hasn't settled, typically if it's abandoned, you could look at that as a settlement and that there's been an agreement to not push it further. But we would consider those. We don't want to create a disincentive to resolving matters, which is why we haven't only said it has to be substantiated, because if you did that, then parties would have a disincentive to come to an agreement in appropriate cases.
Thank you.
Ms. Dorgan.
Thank you. Just two things. First of all, to Mark's point, I think he brought forward a very valid question. Maybe we should today decide that at least as of today it will be for current MPs and current employees, but then possibly maybe come back with some recommendations on to your, Jeff, to your example of somebody who was defeated in an election, but it was whatever may have happened would have happened very currently. That's a different scenario than, there's all kinds of different scenarios that I think bear us looking at, it's worth us looking at them and then coming back with some recommendations.
Michel Patrice, I think Mr. Patrice could give us a thought on this. I think will be helpful.
Yes, and I think it's a very good point that has been raised. Obviously, we could apply the policy to current members and employees, but in terms of former members or former employees, then it's a case-by-case analysis. And if that arises, I would suggest that we come back to the board for guidance in terms, because it varies different in terms of scenario. You could have a sitting member, former employee, current employee, former members, so we would have to have facts of the case to really assess it, and we could come back to the board for guidance in terms of the policy for the future.
I think we're creating greater certainty if we adopt this policy, and I think that as we go forward and consider these things, I think there is a value in having certainty before something happens, rather than when it happens. I mean, I don't think it's ideal for the board to be deciding it case by case. But we may, as Mr. Patrice has said, we may at this point, if we proceed as proposed, we would have to do that in those cases. If we decide later, okay, this is what we should have as our policy and set that out, that's certainly an option available.
Okay, thank you. And then just have one question, and forgive me if this has already been discussed. This is employee to MP. What about employee to employee? I'm thinking of, many times in our ridings, we're not around all the time, and there could be staff to staff issues. Can you just remind me of what the policy is on that?
In terms of the staff to staff issue, if this is something that occurs and it's staff of members, then member, as the employer, you have obligations to resolve those. The harassment policy applies, and the processes unfold. What we are proposing here in terms of legal fees policy would not apply to those types of situations, but would rather apply to situations where there is a complaint against a member, whether it's a complaint that's filed by another member or by an employee of the member.
Ms. Brasso.
Thank you. I would like to thank you, Philip, and the team that worked really hard on elaborating this. I think it's really important that in the context that we're in, staff, people that work in our offices, work in our constituencies, our volunteers and interns, that we're able to kind of level the playing field for them. I just wanted to maybe have some clarification on the reimbursement of legal fees when it comes to the complainants that kind of find themselves in a situation where it's a he said, she said, where there might be lack of evidence. I know that the $5,000 is for the purpose of obtaining independent legal advice. at the outset, and that is where, member and the complainant will have the option to kind of weigh the risks, and then that's when they make a decision whether to move forward with other proceedings. I was just wondering, I'm kind of concerned that because the reimbursements are only possible for those claims that are substantiated at the end of the matter or if the matter is settled. So I'm kind of nervous that this would be kind of like a disincentive to those who feel that they've been harassed, and this might be a way that they feel kind of more nervous and to coming forward. I was wondering if we can kind of maybe get some clarity, and I was wondering if it would be possible to see if the policy could be adjusted to expand the eligibility to those claimants for the legal fees unless the allegations are found to be frivolous, malicious, and vexatious.
Well, to your last point, I think that would be a decision for the board to make. What we are proposing, we feel, is already a departure from the level of support that is ordinarily provided to complainants in situations like this. And what we are trying to achieve is to say, at the outset, you will get this advice so that you can very much assess the strengths and weaknesses and make those decisions. And if it is a very much a difficult case to prove, then that's going to be part of the assessment that's being made. But the person would still be much more supported by having that initial legal support at the outset. And then in terms of moving forward, under this approach, the decision to go to the end of a litigation and to wait for the ultimate decision, that's true. That would be a decision that would have to be made by the complainant, also by the member, because there is no certainty for either, and the policy is very much dependent on that outcome if it goes to a final decision. So that would be part of the decision and the assessment that has to be made. But our goal in this policy is to say that we are providing not insignificant advice so that those difficult decisions can be made, and we are providing that you don't have to go to the end of the matter if it is resolved in another way. The reimbursement can still be available.
Mm-hmm. Okay, thank you.
Mr. Strahl.
I think the concern that both myself and Ms. Madame Brasseau have raised is the wording, if the matter is settled. I think perhaps when I first read that, is that there was a settlement, and perhaps we could just get some clarity. Can a matter be settled without there being a settlement? And I know that's parsing words, but I think if we had some comfort that a matter that was brought forward that was either found to be substantiated, found to be not substantiated, or was simply both parties agreed that, lesson learned or whatever. So perhaps that's where some of these concerns are being raised.
Absolutely.
A settlement can occur. Right, you can settle a case without having a financial settlement. That's what we're talking about, a financial settlement, I think, right?
And I think, as I was responding to one of the questions, I used the word if it's resolved, and perhaps that's a better word, if the matter has been resolved. So it doesn't. You may not have a written settlement agreement and so on and so forth. But the point is that the situation has been resolved and it has ended, but not by way of a decision by a decision maker. So if you agree, we can certainly make that change to the language, because if it suggests that this is somehow has to be a legal settlement of some sort, we don't want to make it unduly restrictive.
So we would change that wording to if the matter has been resolved. Or if the matter is resolved, I guess is the right phrase. Or if the matter is resolved. Is that agreeable to that in terms of that particular provision? Yeah, okay.
Because we obviously only want to be considering these things if there's no possibility that there's further action that could be taken, right? I think we don't want it to just be, we've paid a bunch of tens of thousands of dollars in fees and it might not be over. I think so that resolution would certainly make me happy.
Good. Madame Brasseau?
Just want to clarify, so if there's a situation where there's lack of evidence, another he said, she said, the MP's fees would be paid, covered, and the complainant's fees would not be covered. I just wanted to make sure that we're...
If the matter is not substantiated against the member can claim the legal fees.
Mm-hmm.
If we're in a situation where there has been no decision, so it's resolved, both decide that they want to end it by way of an agreement or whatnot, then both could seek reimbursement of the legal fees.
Okay.
But if there's a final decision,
Yeah.
if the final decision says that there is substantiation of the allegations, then the member cannot claim them. And if it says it's substantiated, the complainant can claim them.
Okay.
Anything else? Then is it the agreement of the board to approve and adopt the proposed legal fees policy as we've just amended and to come into effect immediately?
Agreed?
Agreed. And so ordered. Number 5, amendments to the Board of Internal Economy's bylaw. Back to, en retourne à vous, Monsieur Dufresne.
Mr. Dufresne, once again, thank you, Mr. Speaker. The proposal that we have here is to amend the procedural rules of the Board of Internal Economy and the policy. So I'll go one at a time. First of all, we want to prescribe the circumstances in which board meetings or portions thereof shall be held in camera. The proposal that we are making here is that since the amendments to the Parliament of Canada Act under Bill C-44, the board's meetings are now public. Under 51(1), there are 3 situations that are exempt from that. First, if the matters being discussed relate to security, employment, staff relations, or tenders. Second, if the circumstances prescribed by a bylaw exist, that is 52.2 or 52.5, and those circumstances are present. And finally, if all the board members present at a meeting agree to discuss a matter in camera.
To adopt a bylaw prescribing circumstances in which matters are to be dealt with in camera. Parliament has left it open to the board to consider whether it be necessary or appropriate to include such circumstances in one of its bylaws. And at its meeting of June 8th, 2017, the board asked the House administration to take the necessary steps to prepare for this possibility and to review and prepare draft bylaws for consideration, taking into consideration the best practices of similarly situated bodies and organizations. And so we have done this review and are here to provide you with our recommendation that such bylaw should only include 2 types of situations. The first is matters subject to solicitor-client and litigation privilege, and the second would be sensitive matters respecting the health or family situation of an identifiable individual. And we recommend the inclusion of those 2 types of situations after having reviewed the practices in municipalities, in board equivalents in the Senate and the provinces, as well as hospitals and university boards of directors. And so we've looked at those bodies and the rules of those bodies and the practices, and we have found a general consensus to have discussions about solicitor-client and litigation privilege matters be done in private, and as well to have discussions dealing with personal information relating to individuals to be dealt with in private. Now, in terms of the personal information, we are proposing a narrower scope than the personal information, which can in some cases include financial matters. Our proposal would limit it to matters respecting health or family situation of an identifiable individual, because financial matters may well be relevant and necessary to have discussion in public. But we feel, based on the practice, that situations that would be health matters of, and we say identifiable individuals, so it wouldn't necessarily only be members, but anyone being discussed in terms of the health. Could be a member's child, it could be the health of someone that is being discussed at the board for any reason. And in terms of family situation, we could think of situations of adoption, custody, divorce, these types of things. If they were relevant to the consideration perhaps of a request for an exception or a request for support, we feel would not be appropriately discussed in public. And as well, with the new approach to legal fees that you have approved, there is the possibility of complainants making requests for support that would come to the board, and there again, fundamentally important to protect those individuals and their confidentiality. And so in terms of discussing those, we feel that protecting the confidentiality would be important. It is, as I've said, consistent with practices of similar situated bodies. It is consistent with case law from the Supreme Court of Canada, which has recognized that both solicitor-client and litigation privilege and personal privacy are fundamental quasi-constitutional rights. And so these are elements that we feel would be appropriately included in a bylaw, but we would not recommend anything beyond that, so that the exceptions to the open nature are kept to the strict minimum. So with that, I will open to your questions.
Questions or comments? Mr. LeBlanc.
So again, Philippe, thank you. I think that strikes the right balance for the reasons you outlined, and I'm also pleased that it's consistent with other public institutions and quasi-public institutions that deal with these issues. And frankly, the Senate has for some time before this board became public wrestled with this and has found, in my view, the right balance on some of these personal matters. My question is with respect to security matters. I'm wondering, I remember having been on the board after the difficult events in 2014, and there were meetings, for example, with security officials that talked about improvements that were possible and so on. How would that be a unanimous consent circumstance where if the security professionals were presenting operational changes or expenditures around security equipment, I assume that the board would give its consent to. I don't imagine you have those conversations in public.
Well, in fact, Mr. Leblanc, the board would consent is not necessary, because in the Act, security is already provided for as an in-camera type of discussion. So the first situation where it says the matters being discussed relate to security, employment, staff relations, or tenders. So those are, by virtue of that provision, in private.
And these bylaws go beyond the strict elements of the Parliament of Canada Act, is what you're saying?
Well, those bylaws are contemplated by the Parliament of Canada Act in the second set of circumstances. So it would supplement what is already in the statute.
Thank you.
Anyone else? Okay. In that case, is the recommendation approved and adopted? Agreed. Approved and adopted. All right. Mr. Strahl.
Yeah. I would suggest, just for the sake of not making Philip go through, we would like some more time to consider Part B, the amendment to the Governance and Administration Bylaw. So I would just ask that we table that until a future meeting of the board.
Agreed. Fine, we'll do that. We'll table that and hold off on that one. We're on to, if we're ready, merci beaucoup, Philippe. We're on to the Board of Internal Economy Web Presence Modernization, and this is for information, and le greffier va nous présenter.
The clerk will make a presentation now on this. Good afternoon. Over the last 3 parliaments, the board took measures to provide better communication and, among other things, published its rules and provided more frequent and more ample disclosure of MPs' information and went public with it meetings. For the 2017 budget and following measures, our meetings became public.
In a redesign of the board's web presence, the completion of which was achieved earlier last month. Prior to the completion, an interim solution was put in place for the first public board meeting in October, and many of the features highlighted in this presentation have been accessible to the public since then. The new website features improved navigability and accessibility, a more intuitive user experience, and an aesthetic that is aligned with the branding that characterizes the House of Commons web presence. All information relating to the board's proceedings can be found on the meetings page. This landing page includes webcasting capabilities, general information about meetings, agendas, transcripts, and minutes. Broadcasts of the board's public meetings have also been made available for viewing through our webcasting service, Parlview. Links to audio and video feeds are available for live streaming as well as on demand. Les avis de convocation sont normalement.
Notices of motion are generally produced and published a week ahead of meetings, and there are updates in the days before the meeting. In addition to being published on the board's web page, the information is provided to the public through Twitter and the homepage of ourcommons.ca. The publications search tool has been adapted to allow access to the transcriptions of the board's meetings. The transcriptions can be searched by field, by expression, and so on. And the official minutes are organized and use an indexing method. The meetings section include the most recent information. The travel and expenditure information is available, as well as other reports from the House administration, and these just have to be clicked on.
A wealth of resource material, including the newly reformatted Members' Allowance and Services Manual. The membership page is consistent with the look and feel used for House of Commons committees. In summary, we believe that the new web presence provides a refreshed look, an enhanced format, and a better user experience. So if you should have any questions about the changes that have been implemented to enhance the, as I said, web presence of the board, I'm certainly prepared to try and answer them.
Well, when I think of the fact of broadcasting, it occurs to me I'm glad that the lights here aren't as harsh as they are in the House of Commons, because there's probably a little less glare, for members to have to do that, or for the public to have to see that. Any questions or comments? No? Okay. Merci beaucoup, Philippe.
Thank you very much. Philippe, rather, Charles.
Presentations earlier. So that's an update. On to number 7. This is also an update, I think, on the modernization of printing and mailing householder formats. Alors, on a M. Benoit Giroux, who's Director General Parliamentary Precinct Operations. Aussi, on a, avec lui, je crois qu'on a...
We also have, I believe, Julie Allard. Thank you, Mr. Speaker. I'm here to present an update on the modernization initiative for the printing and mailing of householders. I'll give you a bit of a background. As you know, you approved on June 8th, 2017, the modernization initiative for the householder formats. Right now, we have 28 different options. There are letters, flyers, booklets, and card formats. We looked at how many of these formats were used by various people, and in the new set of formats, there will be 15 options, so letter, flyer, booklet, and card. There will be 1, 2, or full color options. They will be printed on environmental satin paper, which improves the quality of full color printing. These changes are in line with market analysis, and they will provide members with the most up-to-date publishing trends and permit them to communicate with their their constituents using a more appealing product. The consultation took place with political research officers prior to approval by the board, and these officers have been met with and provided with an update in January 2018 as the official launch date nears. We're here today because we want to review the launch. You can see examples here of the various formats and options.
As we launched the transition period, actually a testing period has started with a group of selected members, and we have members from each parties that are participating. And that period started on February 9th and will go till March 30th. And it's basically, they will produce their householder in the new format, and it allows us also to test it and make sure we're ready to implement fully. It will be launched on April 16, 2018. The new suite will be available, and from that date, all new submissions will be in the new formats. Obviously, we will offer extensive support to members to transition, and there will be personalized support as well, and we will even go to assist them in converting their text into the new templates. We also launched a multifaceted communication plan. There will be roadshows to the different members' offices where we will go visit each members and make sure that they have all the available support that they need to transition, as well as we'll provide all type of guides, and we've produced videos on how to on Source, and that will be readily accessible starting end of March and early April.
Merci beaucoup, Monsieur Giroux.
Thank you very much, Mr. Giroux. Questions or comments, Mr. Strahl?
Just comment on the cost per piece, perhaps. Has that, when you go to full color, are we going to see a dramatic increase in costs to members' office budgets or taxpayers in general?
Thank you for the question. If we compare apple to apple, so I'll take example a booklet, a 32-page booklet in the current formats, and a 32-page booklet in the new format in full color. It will be the equivalent cost or less. So all the new formats all the formats that are currently available converted in full color will be at the equivalent or less.
Wow. Good to know.
Sorry. I gather this because we've changed a bit of the size. Is it technology that's changed as well?
What we've done is in the in the design of the new formats. We also ensured that we were efficient in the production of all these formats. We've also, within our current budgets, through our life cycle investment of equipment, we've made a wise choice in terms of investment, so we could produce those at a lesser cost.
Terrific.
So we're maximizing our efficiency.
Good. I'd like to hear that. Anybody else have a question or comment? Très bien, OK.
Thank you.
Ah, oui, excellent. Merci beaucoup, Monsieur Giroux.
Thank you very much, Mr. Giroux. Thank you very much for that work.
Et on est, je crois, à la fin de notre...
I believe we have come to the end of our agenda, the end of our meeting. I have the impression that Mr. Leblanc is a little bit disappointed. I know at the end of the question period, Mr. Speaker, you're always so disappointed that we're already finished. So I see it's the same right here at the board. Thank you very much, everyone. The meeting is adjourned.
Thank you.